Yeah, good morning to all. I'm audible. Hello. Hello.
Sir, audible, sir. Good morning, sir. Audible, sir.
Yeah, good morning. Good morning. Right. So, wait a minute.
Okay, sir.
Is it my screen is visible?
Okay, sir. Visible, sir.
Okay. Right. In last class, we discussed this Minimum Wage Act, Payment of Wage Act 1936. So, this class we are going to cover two acts, that is Payment of Bonus Act, at the same time Minimum Wages Act 1948. So, these two acts we are under block number three. Block number three, two topics we covered yesterday, and today we are covering two acts. That is the Payment of Bonus Act 1948 and also Payment of Bonus Act 1965. Both act we covered today. So every act, the purpose we need to understand first, right? What is the objective of this act? Why it is important? And it's applicable to which industries, which establishment is under in industries? What are the major definitions of this act? Right? And how to fix this minimum wage as per this act. What is the working hours? What is the normal pay? All are covered in this act. So let's understand first what's the objective of this act. So minimum wage act 1948 after independent 1948, 47, 48, the central legislative fix a minimum wage of employment where steward labor is prevented, possible to exploitation, and more particular unorganized sector. So more particular unorganized sector, the purpose. The provision of this act intended to achieve object doing social justice for workmen and scheduled employment. So as we also discussed in the first topic in our syllabus and our paper, see that we have a secular country and our constitution is social justice and equality like that. So based on this act give this objective is social justice for working men employed scheduled employment as they have a right to get a minimum wage as per their work. So this is statutory fixation of minimum wage depending upon the time period, either 5 years, 10 years, 7 years, 8 years. So based on that, the pay fixation, the minimum wage has the right of an employer or a worker. So minimum wage is for bare substance. So like that, this act is a very important and either appropriate government, maybe central government, or state government, or any establishment, they need to follow and fix this minimum wages. Minimum wages based on this, what we call fair wage, living wage, and the minimum wage. So as the market price increases, whenever this inflation rate increases, then as per this NSSO, the labor ministry has decided the labor minimum wage as per this act, right? So what is the need for this? So need for this act is the act is the minimum fixation of wages for the earlier is there 1928 in Geneva, all other nations are there. Similarly, we are also part and parcel of ILO, International Labour Organization. To meet the International Labour Organization standard, so National Commission for Labour has recommended to recommended an extension of the principle of minimum wage to non-scheduled employment also means unorganized sector also they have a right to get as a minimum wage as per this recommendation of this committees. So many committees also appointed the government, appropriate government to decide this minimum wage. So, like as I told you, we have a ILO members in 1928. They decided to deal with fixation of wage where no arrangement exists in regulations of wages all are time. Right? Again, the act aimed to providing social justice to workers employed in scheduled employments and prescribed minimum wage rates, right? So here, when it is the act is enacted and it is applicable to which kind of industries, what the scope of the acts. So this act enforced 15th March 1948 onwards. 15th March 1940 onwards, this act applies any employer or established employee, one or more person, any scheduled employment. So schedule contains a list of detailed employment covered under this act. So first we need to understand which schedule contain all this. So schedule the scope. So it acts applicable all over India, including Jammu and Kashmir. And initially it's applied now when it is initial 1948, 12 employments are mentioned, this act. In 1948, only 12 were added in the schedule. But later it was revised. It was revised, and the state government used the power to bring within the. No, there are, as we told earlier, no, there are three kinds of lists are there: central list, state list, and concurrent list. State, central, and concurrent list. And based on these powers and preparation, they decide the schedule, right? So in initial it is only 12. Now it is more than this 12. And various definitions. So whenever the act is there, first we need to understand the definition of each word. So adolescent more than 18 years, who completed the age of 18 years, and adult 18 years, child it is 14 years, age of below 14 years called as 14 years or less than 14 years is called child as per the section 2 subsection BB. Appropriate government. Appropriate government may be either central government or state government. Means the industries are working under the state government or central government. Some industries, what we call oil refinery, mining, railways, are under the control of state government, central government. So here appropriate government is central government. Some cases state government also included. So employee means a person who has employed higher reward to any work, skilled, unskilled, manual, or clerical in scheduled employment in respect of a minimum rate of wage have been fixed. Include outwork by whom to article materials all are mentioned here. Clean up, it mentioned all kind of works. What is employer? Employer, nothing but is a employer means a person who employs whether directly or through other person, mean third party, right? On behalf of himself, the more. So they mentioned here the manager of a factory defined under this Act 1948. So previous class we discussed the Factories Act 1940, Industrial Disputes Act, Factories Act. There are so many definitions are given regarding this employer. The control and supervision of workers, employees, head of the department, control supervision, depending upon the organization structure, depending upon depending upon the organization structure, the employer will be decided. What is employment? The scheduled employment, it is an employment specified in the schedule or process or any branch of work forming part of such employment given the schedule in the section 2 subsection G. So here we need to understand this. Our act is Minimum Wage Act. So in Minimum Wage Act is first we need to understand the definition of wages covered. Wages covered all remunerations capable of being expressed in terms of money, which would, in the terms of contract employment expression, are implied or fulfilled. So this definition given, the wages definition given, but some are not included. These wages, the section are what are they not included wages are the money value of any house, accommodation, medical attendance, water supply, light. These, if the employer provided, these are not included in this wages. At the same time, any contribution paid by the employer to the provident fund or pension fund under any scheme for social insurance is also not considered under wages as per this act. Third one, the value of any traveling concessions or any traveling this is also not included for this wages. A sum amount paid to the person employed to defray special expenses entitled by him is also not covered. Gratuity also not covered as per. So remaining these all are covered under this wages, right? So how to fix? What are the mechanism to fix this minimum wages? What is the mechanism as central or state? What kind of procedure they followed? Right? It depends upon these various mechanisms are there. First one is different scheduled employment. Say different scheduled employment under subsection. The government may fix a minimum rate of wages different periods by hour. See that sometime hourly base, day base, month base, such a completion of work. So like the various uh, procedure as per the industry work, right? Sometime piece work is hourly base, 8 hours, 6 hours, 10 hours, no, whatever this hour or day, how many days is working, or is a consolidated payment of monthly. So a minimum rate of wage may be fixed by the government for minimum time wage, minimum piece rate, or guarantee time rate, or OT overtime rate. So under section 2, the rate can be fixed as a minimum time. So employee is working for 8 hours. Suppose he is staying 4 hours. So due to shortage of raw material, so there is no work for 4 hours. But still, the employee has to pay full day payment for this employee, right? So 8 hours work cheyali, but only 4 hours work చేశాడు. Then there is no power shortage, or metal is not available, or some issues are there. Then the employee has a right to get full payment, full salary on this period, either 8 hours or 4 hours, whatever the period wage. Minimum piece rate. The piece rate means for పనిని బట్టి వేతనం అనమాట. How much work he has to done. Minimum piece rate. For example, see that he has to, for example, bricks making. He said that per day he has to make 100 bricks. So if it is more than that, he will also get some additional amount of hours. He will get, if it's 50, he will get 50 only bricks amount. If it is do 70, he will do only 70 or 80. It depends upon పనిని బట్టి వేతనం అంటుంది మనం. Minimum piece rate, right? So guaranteed time rate. So guarantee means up to if he come 1 hour, he has to guarantee 50% of salary. Means half percent. It is one kind of. Then after working hours, if he work, the OT rate also decided. OT rates also decided. The rate of minimum wage fix may consist of the basic rate of wage and based on the cost of living allowance and the cash value concession restricted, right? Cost of living. So how the cost of living is decided based on this inflation rate and interest rate, based on this how much amount the customer is disposing and spending the amount. So appropriate government may review and revise the minimum rate at such interval. It may fix every 5 years, not exceeding 5 years. Sometime it may be. So these perhaps say that every 5 years, the appropriate government can take a decision and revise the wage rates. Minimum, not exceeding 5 years. The appropriate government may refine this fixation rate in respect of the any scheduled employment which less than 1,000 employees are employed in as a whole. So that is also as the states also mentioned. So the constitution of minimum rate of wages also decided here. The basic rate is also known as cost of living allowances, all are mentioned. So the procedure of deciding the minimum wage rate and revise this minimum wage rate that mentioned in this Act, Section 5. So the first they need to appoint any appointment committee, many committees or subcommittees that may necessarily hold the inquiry advice is no, to fix the rate. So what first is government no, appointing one committee and see that based on the issues they also appointed subcommittees. So recently, this last week, we have seen that central government appointed is planning to appoint eighth pay commission, right? Eighth pay revision commission. So then it will take 1 year time is given, then it's implemented. Government will take, government will also decide. Even state governments also appointing pay revision commissions, right? So central government is every 10 years, the state government every 5 years. Maybe it may be sometime the implementation part, it will take 1 or 2 years additional. The forward method uh, could be called committee procedure, and the later method is be called notified procedures. So wherever these committees are there, they ask these opinions of the employees, various stakeholders, submit their concern, all this. So provisions relating to wages, kind, normal working day payment of OT overtime. Right. The provisions of this act related to wages in kind of normal working days, the payment of overtime, or wages of workers who work less than the normal working days, and wages more, these are mentioned here. So wages kind is mentioned section 11, and normal working days. So even Sunday also, if you declared Sunday is a holiday as appropriate government, as an employer's right to get Sunday salary also. Right. Sunday salary also have the right. Suppose Sunday is working day and the Monday is holiday. The establishment declared holidays, but employees, employment worker has also get this payment. In regard to any scheduled employment, which minimum rate has been fixed, appropriate government, the fixed number of working days, working hours, normal working days, inclusive one or more intervals. So intervals is nothing but the Sundays. So provide a rest day with wages vary period 7 days. So rest period also has a right to get salary. So in scheduled employment, where is mentioned the payment of overtime if the employer working more than the prescribed hours. So 8 hours, if they work more than 8 hours, he has to get additional payment for this, whatever the hours he spent in these organizations. Wages of workers who work for less than normal. So if he working normal then he has to get the minimum wage. Suppose he has to work 30 days, means 24 working days, but he worked in 20 days or 18 days, he has to entitle the full salary or a minimum wage at least, whatever the minimum wage mentioned, 21,000 or something. So that he has to get. Why? Because he has to survive and has to has constituted that social justice. Wages for two more classes of workers. So when that will be decided based on this work classes under section 16. The minimum rate, wage of piece rate, as earlier we discussed, right? How many bricks he has make based on that he has climbed the salary wages are section 17. So maintenance and register and record. So employer has duty to maintain the registers and records of employees and his pay details and his allowances. Everything is covered under section 18. All the establishment has to maintain separate record for these wage payments particulars. Right. So then, what about authorities? Advisory board. An act empowered the government to constitute an advisory board to see the advisory board, the equal members of both employer and employee. Right. So ఇద్దరు ఉండాలి దీంట్లో యూనియన్ అడ్వైజరీ బోర్డులో. Then only they come for in conclusion, or else say that those side appointed by the employer, so they feel that they're paying higher salary as these wage as these workmen say that it's a less salary, right? Less salary one side, higher salary one side. So if any disputes are there, sit together and resolve it. అంటే రెండు వైపుల నుంచి కూడా ఇందులో మెంబర్స్ ఉండాలి, ఈక్వల్ మెంబర్స్ represented both employers and employees, and to coordinate the work committee and subcommittees appointed by this fixation revision of minimum rate of wages. And Central Advisory Board, the Central Advisory Board is empowered to constitute Central Advisory Board to advising central states in the matter of fixation revision minimum wages due to coordinate the work. So under section 8, the Central as Advisory Board is also appointed in consultation with states. Some committees and subcommittees also appointed for various similar, there is unique issues are there. Under this, inspection officer also is that is inspection officer is appointed as per section 9, section 19 and subsection 2. So he will verify all the reasonable hours, any premises, place where employees worked properly or maintained or not, or they pay the fixed pay or not. Everything is inspector officer can be verified at any time. Then clients, if any appropriate government may appoint, notify the gazette. So once is gazette declared, right? For example, what any act will pass first is the act will be introduced in the Lok Sabha or Rajya Sabha, or both houses are passed the bill. Then the bill goes to this president. Then president agreed. Then bill is converted into act. So based on the act, the official gazette will be issued. Notification, gazette notification issued. Then then onwards it says it is legalized. It is legalized. No, official gazette available. An authorized look at the claims respect the payment of less than minimum rate of wages, payment of remuneration. So all are covered in this gazette notification, right? The application claim shall be prescribed within 6 months of the date. If any delay in filing application for after 6 months, maybe consolidate sufficient cause, right? So cognizance offences, if any offences are there between this, no, he will they approach the appropriate government to redress the issue, right? And powers of central and state government, section 26 to section 30. So as Minimum Wage Act, they given the power, both appropriate governments, the central government and state government have a power to decide this minimum wage rate as per the section 26 and to 30. That means there are five sections are clearly mentioned, the appropriate government. State government to add to the schedule. The state government can be add new establishment under this act. The central government is also given the direction. The central government is empowered to give the direction state government to carry into execution of this act into the state. The central government to make a rule also. So like the liabilities of the employers, as mentioned, this section 11, 12, 13, 14. So these act. So here also, if this act is not appropriately mentioned, some penalties also there. So where a claim by an employee is found to be molecules is very 50 rupees or 500. It's as you know, whenever this 1948, this amount is big amount. Now the amount is very meager amount. So miscellaneous provisions also there. Any corrections of error, all this mentioned in this act. So on the whole, the act is very mentioned. So every 5 years or every 7 years, 10 years, appropriate government may revise the pay scales, revise this minimum wage as per this act. So there are so many amendments happen in this act also. Whenever this new change is happening, they also change. Any doubt regarding this? Any doubt, Mehboob and please anyone? Any doubt regarding the minimum wage act? Hello? Any doubts? Any doubt? Then we move to next topic. We'll move to next topic. That is payment of bonus act. So first we need to understand what is meant by bonus. It is all the forms are right. Payment of bonus act 1965. So first now everyone we the employees. So which kind of employees are eligible to get the bonus? Which industries are declared the bonus? Any criteria is there? Why bonus is declared? So like we have various questions. Why only few industries are applicable the bonus and why not others? See what kind of we have so many doubts are there if you see the newspaper. So Singareni calories in Deepavali they declared or in Karnataka they declared Dasara. The railways employees also getting bonus, right? Why not others? Why not the state government cannot get the bonus? Why the central government not get employees? Why not the bankers cannot get the bonus? Why only people are getting? So like we have so many doubts regarding this Payment of Bonus Act. So let's discuss one by one and regarding this act, Payment of Bonus Act, why it is existence, right? So this period, right, in during we have seen 1917 First World War, 1935, 19 third period Second World War, are there. Bonus is something paid, gesture as a goodwill, nothing but no, their definitions are given. It's kind of profit distribution, right? Whenever the profits are there, the salaries are not up to the mark. If the industries get the good returns, good profit, the employer and see that employee contribution also included if the firm get a good profit. ఒక సంస్థ మంచి లాభాలు వచ్చాయంటే ఆ సంస్థలు పనిచేసే ఉద్యోగులు కూడా వాళ్ళ కాంట్రిబ్యూషన్ లేకుండా సంస్థ లాభాలు రావు. Then at the same time, the where the workers or employees have a right to get additional amounts. So here see that the bonus is the beginning was considered as a extra great payment, such as consideration and derogatory the point with. But in the Constitution, even the Article 43 here mentioned, nothing work endorsed here is mentioned, right? So therefore, the fair that work, right? Fair that workers should be paid due. So, like it is also the act is the term bonus is neither defined in this act nor any other laws. But Bonus Commission of India appointed the government in the year 1930, 1961. Right? As you know, if any act is there, first the very most important one is definitions. But before there is no definition, but the Bonus Commission of India appointed by the central government in the year 1961, they defined what is the bonus? It is difficult to define in a rigid terms the concept of bonus, but it is possible to urge that once profit exceed in a certain base, the profit exceeds certain base. If the profit exceed certain base, laborers today legitimately have share them. So if the profits exceed certain base, the labor has legitimate to have a share in them. In other words, we think in a proper constructive concept, the bonus as sharing by the workers, the prosperity concern which then whatever the profits are, good profits are there, they need to get a right to gain it. However, see this act is clearly mentioned. Uh, Whatever this profits are distributed to these employees. This object of this payment of bonus act 1965 is to provide the payment of bonus to persons employed certain establishments on the basis of profits or on the basis of production. See here, this act is applicable certain establishments on the basis of profits or on the basis of production. So it's not applicable to all establishments, right? Certain establishments only. They clearly mentioned certain establishments, employees working in certain establishments are only eligible for this production, right? This act, the act extends the whole India, including Jammu and Kashmir. Act shall be applicable establishment 20 or more work employed account, right? 20 or more workers employed in a day during accounting year. Accounting year means starts with April 1st to 31st March, right? However, the subsequent reduction strength, so it's also there. So minimum 20 or more workers are there. They need to add, right? Accounting period, as I mentioned, 1st April to 31st March. Allocable surpluses. If the surpluses are there, they only they can distribute. Sometimes if the firm doesn't get any profits, they then also they need to pay bonus. So in this act, say that at 67% of the available surplus in accounting period, in any case, 60% such available surplus also distributed. Appropriate government, as I told you, the central government is appropriate government and the central government is also appropriate government. Right? Available surplus, it means available surplus computed under Section 5 of this Act. Award nothing but the judgment, right? Judgment as per Industrial Disputes Act, Labor Code, they mentioned the award. The company is clearly mentioned, Companies Act 1956, and now have a new act, Companies Act 2013. The corporations is also mentioned, central and states is mentioned. So who is the employee, right? And employer. Employee means any person, the appropriate not exceeding the salary of minimum 10,000 per month. 10,000 per month. It is initial period 1965 days, right? So employer is also mentioned the factors at 1948 and the right. So salary is also we discussed earlier. So the definition of salary and wages are clearly mentioned. So these are not included, but these are not included under salaries or wages as per this act. And then who are this eligible for bonus, right? So as I told earlier, certain establishments are only eligible or they all are not eligible, right? For every employee shall be entitled to be paid by his employer according to accounting year. Bonus in accordance with the provision of this act and provided he has the worked establishment 30 days in a year. So minimum 30 days he has to work in a year. Then only he is eligible for get this bonus. So whatever the certain establishments, if employee has to work 30 working days in that year, then only he is eligible for bonus, right? So disqualification bonus if any employees do the fraud and any theft or misappropriation or all are there, he is not eligible for getting this bonus as per this Act Section 9. Bonus Section 9. The payment of minimum and maximum bonus. What's the minimum and maximum bonus are decided, right? So minimum is certain amount and maximum is see that this section 10. Section 10 is mentioned, provided that where employee has not completed 15 years of service at beginning of this period. So based on the service years also considered for deciding this maximum and minimum payment, payment of bonus. So section 10 of this act is non-violated Article 19 and 13 Constitution. Right? Even if the employee suffer losses during the accounting period, he is bound to be paid minimum bonus prescribed as per 10. So minimum bonus is clearly mentioned section 11 as per this act. So where in respect of any accounting year, section 10 is applicable. So it is not more than certain period. See that the maximum percent of such category of wages is 20%. The maximum is 20%, the minimum is certain percent they have to declare as a dividend. So calculation of bonus with respect to this certain employees. See the bonus will be paid a minimum of 8.33 and maximum 20%. Where see if the employee get the every month 7,000 salary, so as per this act, so he will get minimum is 7.3 and 20%. So in between the government, appropriate government decide the bonus, right? The appropriate government may decide either 8.33 or it is 10% or 15% or 18%, not exceeding 20%. Proportion of reduction in the bonus in certain cases. So certain cases, if this where employee has not worked for all working days in accounting period, then the minimum bonus 100 rupees or as this case may be fixed 60 rupees, the bonus if the bonus is higher than 8.3% the wage, right? So computation of working days is considered he has been on leave on with salary and wages all are considered for deciding bonus and set off allocable surplus also there if this is also mentioned this act these sections. So adjustment of compulsory in interim bonus. So compulsory or interim bonus in between. Either interim means in between the 6 months, anytime the company can decide to pay this dividend instead of paying only 1 year, they can pay two times in a year to decrease the cash flows out, right? And reduction of certain amount from this bonus is also there. So time limit for payment of bonus, they clearly mentioned with the declared the dividend or bonus they need to pay before certain period. So authorities duties and procedure for this act. See that Industrial Act, Industrial Disputes Act will have a labor court, industrial tribunal, national tribunal, arbitrate is also there, right? As per ID Act, Industrial Disputes Act, and inspectors also appointed as per this act. And cognizance offenses. If any offenses are there, they need to approach appropriate authorities to redress the issue. So liabilities. Wait a minute. Yes. Liabilities section 4, 5, 6, 7, 14 also mentioned. So here is also mentioned like calculation of amount. So they calculated the surplus of 67% company, 60%, and the competition also clearly mentioned here. And direct is also there. It's not applicable. These is not applicable all kind of establishments. Only certain establishments also declared, like RTC employees and see that railways or some organizations. They only they are eligible for getting this bonus as this government organizations. They won't declare the bonus addition. Why? Because these are non-profitable organizations where the organizations working for profitable, like railways, they work for profitable organizations. Their motto is service come revenues, right? What we call socio-economic objects. Socio-economic objects, right? Synchronic is also providing production electricity at the same time. They also generating revenues like RTCs, like some organizations. They work hard. They're contributing to the production, or say that getting the good revenues to the management. They are eligible for get this bonus. So here, this is the bonus. So any doubts so far? Any doubts? Any doubts? Or can we move for next topic? Any doubts? Hello? Any doubt? We have covered two acts, the Minimum Wages Act 1948 and the Payment of Bonus Act 1965. We covered both acts so far. So we covered uh, four acts under block number 3. Now we are going to move block number 4, Equal Remuneration Act 1976. So this act also, what is the need and objectives, and when it is commenced and what is the applicability of this act, and as the definitions and override effects also there. Remuneration for equal remuneration for men and women of working hours. No discrimination between these recruiting men and women. And what are the authorities, their duties, their functions, and their liabilities is also mentioned in this Equal Remuneration Act 1976. Equal Remuneration Act 96. So to address these gender issues here, right? So as per this act, the principle of equal work of men and women gaining increase. See that. So address the issue is the equal work for men and women. Working has been gaining increased acceptability overall the world, right? So here this act, see that one of these very important 1975, even though declared International Year on the eve of announcement of International Women Year. International Women Year, UNO declared in the year 1975. The President of India promulgating the Equal Remuneration Ordinance in 1975, and Act is 26 September 1975. So specific, the reason is there. UNO declared in 1975 International Women Year. At the same time, President has given a separate ordinance for this Equal Remuneration Ordinance 1975. The Act is 1976. So equal payment for equal work, irrespective of gender, right? To aim to provide for the employment of equal remuneration to both men and women. So equal remuneration means the basic wage, salary, and any other additional amendments are not covered in this, right? What kind of the central Industry relations mechanism, machinery is working under the Ministry of Labor to responsible for enforceable this act. So in our country, see that women labor has always been discriminated in workplace, some other issues, especially when it comes to payment of wages uh, to them via when male workers, right? So like to reducing this issue, then Article also 15 says about Indian Constitution provides provision of discrimination on ground of religious and grounds of religious, race, sex, caste, place of birth, right? So this is also our Constitution also clearly mentioned, right? Right to uh, right provision all this. Then Article 39 also Constitution is that state shall direct its policy among other things towards securing that there is equal pay for equal work, both men and women. So equal pay for both men and women. So hence the President of India issued a separate order in 1975, but the act was replaced. Equal Remuneration Act, the ordinance was replaced, and under this Equal Remuneration Act, 1976. So Equal Remuneration Act provides the payment of equal remuneration both on men and women to workplace, similar work of nature, any other discrimination is also covered. So here the object is very clear, right? And commencement applicability. So it will be forced as an ordinance issued. It shall be forced such as date being is not 3 years from this passing this act. The central government may define this. So act does not define premise, establishment, factory, industry, and work. It's not decided. Why? Because in the previous acts, it's also decided, right? And we have so many acts previously. They decided what is this premises, what is the establishment, what is the factory, what is the industry, what is the workers. So the same was implemented here also to avoid this confusion and different definitions. So as per Industrial Disputes Act, Industrial Disputes Act 1947, it's declared any discharge, any industry carry out under authority of the central government. So like they also established worker all decided, right? Whatever these definitions are 1947 Industrial Disputes Act are same applicable here also. And Section 15, when a special treatment given to a woman employment under any law to special treatment according women according with birth child and see that they give the woman employee can get this maternity benefit leaves or separate additional leaves as per this section 15. uh, Section 16, when a central or state government declare that the differences with regard to remuneration or particular spacious remuneration, men and women may establish and employ within that whether there is no discrimination between these salaries or wages. So appropriate government, as I told you earlier so many times, so they declared central government as appropriate some situation, state government appoint situation as per this powers. So here see that this some organizations under the part of central government. So these add banking companies, mining, oil refinery, oil fields, major ports, or any corporation establishment or any under central government is an appropriate government. State government is appropriate for the state issues. So yearly section 2 subsection D, given the definition of men and women, right? So remuneration is also is clearly mentioned, uh, section 2 subsection G. So remuneration is differ for wages. So it means the basic wage or salary and any additional whatever payable either cash or kind, cash or kind to a person employed in a respect of employment or work done in such employment, right? So here some definitions are there. Act to have a override effect. So to avoid override effect, this act also clearly mentioned section 3. Act provide that the provisions of act such shall affect notwithstanding any other inconsistent way like mentioned given definition. So equal remuneration to the men and women workers, right, is also clearly mentioned. No discrimination while recruiting men and women, right? You have to give them more equal opportunity for men and women in this whenever they recruit. So as per this Act, Section 5, so employer while taking recruitment for the same work, so he give this opportunity for both men and women in any conditions of service, subsequent recruited such a promotion, serious promotion, training, transfer shall not be shall not make any discrimination against women except where the employment of men is clearly mentioned here. Right? Then authorities and their duties, power for procedure under this Act. Advisory committee. So, like the appropriate government may constitute appropriate advisory committees uh, to address if any issues are there, right? So, appropriate government constitute one or more committees to advise with regard to extent to which women may be employed in such employment or establishment. Central government may be notified. So, similarly, the state government also doing same. So every advisory committee shall be consist of not less than 10 persons nominated by this appropriate government. So any advisory committee, the minimum number is 10. Right? Authorities for this hiring and deciding claims and complaints. Right? Whatever these advisory committees are there, they need to hearing and decide these advices. They give advice, right? But appropriate government can take a decision. Not this, no, this the word itself indicates only advisory, right? Then this appropriate government can take a decisions. So inspectors, their duties are there under section 9. So liabilities also mentioned section 8. And these are the very basic Equal Remuneration Act, both men and women. So these are some offenses. If the offenses are there, these are this penalty can be imposed, right? So failure or vision to maintain any register or other document in relation to workers employed. So sample impersonate up to 1 month, nor with fine up to 10,000 will be there, right? So offense is also any mentioned here. This is a recovery of right. Is also there. So like this is this Act Equal Remuneration Act 1976. Now we move to one more act, Work Workmen Compensation Act 1923. So this act will be discussed in next class. Now you have any doubt, please? You have 4 minutes of time. You have any doubt, please? Hello, hello. Right. Let's summarize our total entire syllabus. And so far we covered block one, three acts, and block four, four acts are there are four. See that here the two acts are there. Here also two acts are there, right? And today we covered three. Three acts we covered Payment of Wages Act. Yesterday we covered Payment of Wages Act. Now today we covered three acts, that is Minimum Wage Act 1948 and Payment Bonus Act 1965, Equal Remuneration Act 1976. We covered three blocks so far. And the remaining two blocks are there. In next class, we cover two different blocks, and fourth block and fifth block. Fourth block, the topics are Workmen Compensation Act 1923. Workmen compensation, right? So how the organization can be compensate these employees as per this Act 1923, and Unit number 13 is it talks about ESI, Employees State Insurance Act 1948. Then unit number 14, Employees Provident and Miscellaneous Provisions Act 1952 and Payment of Gratuity Act 1972. Here also the very important uh, acts as per this legislation on social securities, right? And 15th units, the Contract Labor Regulations and Abolition Act 1970 and the Maternity Benefit Act 1961. And these all four acts are covered on block number 4. Then block number 5, the last unit, we are going to discuss the contemporary issues related to this related to child labor Prohibition Regulation Act 1986 and sexual harassment of women at workplace prohibition and redressal act in 2013. So this is in the issue of Nirbhaya case, this act is there, right? In the last one is IT Act 2000 is also very important for working regarding to working hours, amount of facilities, all are right. So we have another two blocks are due. So next class will complete these remaining syllabus. Thank you all. You have any doubts, please? Mehboob, any doubts? Or can I stop here? Any doubt or can I stop here? Hello?
No, sir.
Okay, okay.
Okay, sir. Thank you.
Thank you.